The Oregon Department of Energy and the Energy Facility Siting Council want to make sure Oregonians understand how they can engage in the public energy facility siting process for state jurisdiction energy facilities. In this presentation, we'll go over the contested case threshold for a Type A amendment request and explain how that differs from the contested case threshold for a new application. After a developer receives a site certificate to construct and operate an energy facility, they can request an amendment at any time during the life of the facility. There are many reasons a site certificate holder may seek council approval of an amendment. Examples include extending construction deadlines, adopting newer technology, expanding a facility site boundary, adding a new facility component, or transferring the site certificate to a new facility owner. The council's amendment process can take a number of months depending on the scope of the amendment request. There are three amendment process types. The default is called a Type A review, which is what we'll discuss in this video. It includes a public hearing and the opportunity for a contested case proceeding. The Type B review includes a written comment period but no public hearing. Type C reviews, only available before a facility starts operating, are reserved for unforeseen and unavoidable circumstances. The type of review is determined by many factors, including complexity, public interest, likelihood of significant adverse effects, and the type or amount of mitigation, to name a few. While there are differences in these processes, the site certificate holder still has the burden of proof to meet all applicable council standards associated with their amendment request. Let's start with a brief overview of the steps in the amendment process. It starts with the amendment request. This is the document where the owner of the project, the site certificate holder, explains their request to amend their facility and how they believe it meets all of the applicable standards. The draft proposed order is the Department of Energy's first recommendation to the Energy Facility Siting Council about whether the request for amendment meets all of the applicable standards. This stage includes a public notice, a comment timeframe, and a public hearing in proximity to the location of the project, and how comments are made relate to the ability to request a contested case later on. Based on all of the comments received during the draft proposed order, the Department of Energy may make changes to its evaluation and recommendation about whether the amendment meets all of the applicable standards in the proposed order. The next phase is the contested case, where an independent hearing officer reviews issues that are raised during the draft proposed order phase and that are eligible to continue to be reviewed. The applicant and the department are automatically parties to the contested case. Unlike a new application where a contested case is a mandatory part of the process, in a Type A amendment, a contested case is possible but not mandatory. People who commented on the record of the draft proposed order must submit a request for contested case proceeding that includes the necessary information outlined in the notice of proposed order and opportunity to request contested case. At the conclusion of the contested case, or the proposed order if there is no contested case, the Energy Facility Siting Council will make its final decision in the form of the final order. If they approve the amendment, they will simultaneously issue an amended site certificate. This slide shows the specific thresholds for a contested case in a new application and in an amendment. You can see that an amendment includes all of the same requirements of a new application, but has one addition regarding comments. In both cases, a comment has to be within the comment timeframe associated with the draft proposed order. That is usually in the range of 30 days, but could be more or less than 30 days. Please make sure you pay attention to the notice of the draft proposed order. It will tell you the comment timeframe and how to submit comments. Next, the issue or issues in the comment have to be within the jurisdiction of the council. All of the applicable standards that apply to the request for amendment will be included in that draft proposed order. Comments also have to be sufficiently specific enough to convey your concerns so that the site certificate holder, the council, and or the Department of Energy staff can evaluate your concerns in order to be able to respond to them in the proposed order. It's important to remember that the state review process is an evidence-based process. The Department of Energy relies on evidence and facts in their draft proposed order in order to make recommendations on whether the site certificate holder has met every applicable standard in the amendment review. If you believe the department has made an error in coming to a specific conclusion, please make sure you provide evidence to support your position. Finally, specific to the amendment process, your issue must be a significant issue of law or fact associated with the changes that have been proposed in the amendment, and be reasonably likely to affect the council's determination that a specific standard has been met. The scope of council's review for amendments is designated under Oregon Administrative Rule 027-0375 and varies depending on the type and content of the amendment request. If the council receives a request for a contested case in a Type A amendment, they have three options. The first is to hold a full contested case because they believe an issue raised is significant enough that it may affect their determination on whether the amendment request meets all applicable standards. The scope of council's review when evaluating this question depends on the type and content of an amendment request. For example, in a request for amendment proposing to add new area to a site boundary, the council must first find that the evidence on the record supports that the portion of the facility to be added to the site by the amendment complies with all laws and council standards. If council decides to hold a full contested case, they will appoint a hearing officer to run it. The second option is that they believe an issue raised is not significant enough to warrant a contested case, but significant enough to send the proposed order back to the department in order to make changes to findings of facts, conclusions of law, and/or conditions of approval. Option 3 is that council concludes that one or more of the threshold requirements reviewed on the prior slide is not met and denies the request to have a contested case. In that circumstance, they will proceed directly to the final decision on the amendment. Let's walk through some general points to be aware of when there is a contested case associated with a Type A amendment. First, only those issues that the council determines to be part of the contested case will be evaluated. Council may limit parties to issues raised and/or allow full or limited participation in the contested case proceeding. The council appoints an independent third-party hearing officer to manage the contested case. Currently, those are administrative law judges with the Oregon Office of Administrative Hearings. At the conclusion of the draft proposed order stage, the record closes. However, during the contested case, the record is partially reopened to allow new information to be included in the record associated with the issues in a contested case. At the conclusion of the contested case, the hearing officer makes a recommendation only on the issue or issues that are part of that contested case. While there's no requirement to engage an attorney to participate in a contested case, please be aware that there are more legal nuances than in other stages of the energy facility siting process. So if you do plan to participate in a contested case without an attorney, please be prepared. The amount of time spent on contested cases vary, depending on the number of parties, the number of issues, and the complexity of issues. However, contested cases associated with a state jurisdictional facility typically have the same steps, which we've outlined on this slide. Thanks again for tuning into this short video to learn more about contested cases and the Type A amendment requests. Public engagement is an important part of Oregon's energy facility siting process, and we hope the information we've shared helps you better understand how to engage. On this final slide, we've included some important Oregon administrative rules related to a Type A amendment contested case. Find more resources, including links to administrative rules and our public guide to the energy facility siting process, on ODA's website.